Today the court has pronounced itself on our client, that is Rafael Kimani, the second convict, and the court has sentenced him to the sentence of death as provided for under the statutes in section 295 and 296. We are not satisfied with the decision of the court. We shall be moving to the High Court to challenge that decision. It looks a tall order, but I'll give a chronology why this is not a tall order. You can see the mother of Rafael is present. All the mitigations that we did, nobody took interest of those mitigations. It was academic. There was no need to put the convicts to mitigation, to look for the probation officers to do a pre-sentence report, when, according to the court cannot move one step backward. But this is not new. Previously, all murder convicts had only one sentence, death, until Senior Counsel Fred Ngatia took up the matter and took the angle of how constitutional the sentence is. The matter moved from the magistrate's court to the High Court, to the Court of Appeal, to the Supreme Court. Muruatetu 1 made murder, convict of murder, can be jailed for 1 day, can be jailed for 1 year. A comparative approach towards a robbery with violence, where nobody has lost life, compared to where somebody has lost life. A killer goes home with 2 years or 3 months or 1 day. But robbery with violence is death sentence. We are determined to move to the Supreme Court for that to be determined. Remember, we are aware 3 judges declared the offense of robbery with violence as unconstitutional. The decision, we are awaiting the judgment over that question. The implementation of the offense of robbery with violence, which is an illegal sentence. It is an illegal because the ingredients of robbery with violence are vague, are ambiguous. But the judge, the magistrate, has pronounced himself. We respect the decision of the magistrate, but we do not agree with the findings of the court. We shall be moving to set precedent so that mitigation does not only apply to people who have committed murder. Article 27, equality of the law. Offenses are the same. Why should murder convicts be treated with kid gloves, while convicts of robbery are not given the same preferences? So we shall be coaching our petition in a constitutional manner that this is discriminatory because others are granted that. Remember, Muruatetu 2 was a decision where nobody moved the Supreme Court. The Supreme Court moved by itself the concept of suo motu and provided guidelines that Muruatetu 1 only applies to murder. So now we are going to beckon on the door of the Supreme Court on Rafael Kimani, which the Supreme Court must deal with. The Supreme Court cannot make a specific law to deal only with a specific offense. All criminals or offenders are the same in the eyes of the law. And that is what Article 27 provides for. The limitations provided under Article 24 cannot be limitations only for robbery with violence victims, again excluding the murder suspects. We are appealing to the family to be firm. The journey will be long, but we are determined that Rafael Kimani one day will see the outcome and take this bright sunlight that the lawyers and the family and the media are enjoying. Asante.